statement of objects and reasons of the NDPS Act makes it clear that to make the scheme of penalties sufficiently deterrent to meet the challenge of well-organized gangs of smugglers and to provide the officers of a number of important central enforcement agencies like narcotics, customs, central excise, etc., with the power of investigation of offences with regard to new drugs of addiction which have come to be known as psychotropic substances posing serious problems to national governments. This comprehensive law was enacted by Parliament enabling exercise of control over psychotropic substances in India in the manner as envisaged in the Convention on Psychotropic Substances Act 1971, to which India has also acceded, consolidating and amending the then existing laws relating to narcotic drugs, strengthening the existing control over drug abuse considerably, enhancing the penalties, particularly for trafficking of offences, making provisions for exercising effective control over psychotropic substances, and making provisions for the implementation of international conventions relating to narcotic drugs and psychotropic substances to which India has become a party. Let us consider the scheme of the NDPS Act and its relevant provisions. The 1985 Act came into force on 14/11/1985. Certain provisions were subsequently amended in 1989 and in 2001. Chapter 4 deals with offences and penalties, whereas Chapter 5 deals with procedure. Section 41 relates to power to issue warrant and authorization. Section 42, with which we are concerned, relates to power of entry, search, seizure and arrest without warrant or authorization. Section 43 relates to power of seizure and arrest in public place. Section 50 refers to conditions under which search of persons shall be conducted. The NDPS Act prescribes stringent punishment. Hence, a balance must be struck between the need of the law and the enforcement of such law on the one hand, and the protection of citizens from oppression and injustice on the other. This would mean that a balance must be struck in the provisions contained in Chapter 5 intended for providing certain checks on exercise of powers of the authority concerned are capable of being misused through arbitrary or indiscriminate exercise unless strict compliance is required. The statute mandates that the prosecution must prove compliance with the said provisions. But PW2 Inspector of Police at Daryapur Police Station got information on 12/1/1988 that one Iqbal Saeed Hussain was trying to transport charas up to Sahapur in an auto rickshaw. At about 4 p.m. they sighted the auto rickshaw, which was then driven by the appellant. They stopped and checked it and found 4 gunny bags placed inside the vehicle. The police took the vehicle to the police station, and when the gunny bags were opened, 10 packets of charas were found concealed therein. The value of the said contraband was estimated to be rupees 5.29 lakhs. When appellant or the accused was questioned by the trial court under section 313 of the Code of Criminal Procedure, he did not dispute the fact that he rode the auto rickshaw and the same was intercepted by the police party, and the gunny bags kept in the vehicle were taken out and examined by them at the police station. His defense was that those 4 gunny bags were brought in a truck at Chokha Bazaar by 2 persons who unloaded them into his vehicle and directed him to transport the same to the destination mentioned by them. He carried out the assignment without knowing what were the contents of the load in the gunny bags. The trial court acquitted the accused, but State of Gujarat preferred an appeal before the High Court. The division bench of the High Court set aside the order of acquittal and convicted the accused of the offences charged. The convicted accused filed SLP before this court and contended that there was non-compliance of section 42 of the Act, which was enough to vitiate the search as a whole. After referring section 42 of the Act and the evidence of police officer as PW2, the court held that first, he should have taken down the information in writing, and second, he should have sent forthwith a copy thereof to his immediate official superior. After finding that PW2 police officer admitted that he proceeded to the spot only on getting the information that somebody was trying to transport a narcotic substance, and noting that PW2 admitted that he proceeded on getting prior information from a constable, and the information was precisely one falling within the purview of section 42 within bracket 1 of the Act. The court decided that PW2 cannot wriggle out of the conditions stipulated in the said subsection and unhesitatingly found that there was non-compliance of section 42 of the Act. The state contended before the bench that such non-compliance with section 42 of the Act cannot be visited with greater consequences than what has been held by the Constitution bench regarding non-compliance with the conditions prescribed in section 50 of the Act. After referring to the dictum laid down in state of Punjab versus Baldev Singh, this court held that the views expressed with reference to section 50 of the Act would apply with reference to section 42 also, and consequently held as follows -para. If the officer has reason to believe from personal knowledge or prior information received from any person that any narcotic drug or psychotropic substance within bracket in respect of which an offence has been committed bracket close is kept or concealed in any building, conveyance or enclosed place, it is imperative that the officer should take it down in writing, and he shall forthwith send a copy thereof to his immediate official superior. The action of the officer who claims to have exercised it on the strength of such unrecorded information would become suspect, though the trial may not be shaped on that score alone. Nonetheless, the resulting position would be one of causing prejudice to the accused party. It was also contended by the Council for the State of Gujarat that as the accused did not dispute the factum of recovery of the charas from the vehicle, it does not matter that the information was not recorded at the first instance by the police officer. The court did not approve such contention because it held that non-recording of information has in fact deprived the accused as well as the court of the material to ascertain what was the precise information which PW2 got before proceeding to stop the vehicle. It further held that value of such an information, which was the earliest in point of time for ascertaining the extent of the involvement of the accused in the offence, was of a high degree. It further held that it is not enough that PW2 was able to recollect from memory when he was examined in court after the lapse of a long time as to what information he got before he proceeded to the scene. Even otherwise, it held that the information which PW2 recollected itself tends to exculpate the appellant rather than inculpate him. Finally, the court held that non-recording of the vital information collected by the police at the first instance can be counted as a circumstance in favor of the accused. On analyzing this as well as the other materials, this court ultimately allowed the appeal filed by the accused of the appellant and set aside the conviction and sentence passed on him by the High Court and restored the order of acquittal passed in his favor by the trial court. The ratio is Abdul Rashid Ibrahim Mansoori Supra is that the non-recording of vital information collected by the police at the first instance can be counted as a circumstance in favor of the accused appellant. The police officer examined as a crucial witness PW2 in that case admitted that he proceeded to the spot only on getting information that somebody was trying to transport a narcotic substance but failed to take down the information in writing, nor did he apprise his superior officer of any such information either then or later, much less send a copy of the information to the superior officer. Thus, it was a case of absolute non-compliance with the requirements of section 42 within bracket 1 and within bracket 2. The state